A mistake of fact is a misunderstanding of a fact that can be used as a defense in criminal and civil law. A mistake of law is a misunderstanding of the law that is really a defense. Mistake of fact. 1. A mistake of fact occurs when someone has an incorrect belief about a fact that is relevant to their actions. 2. A mistake of fact can negate the intent to commit a crime, especially if the crime requires precise intent. 3. For example, if someone is charged with theft but believed the property was theirs, they lacked the intent to steal. And 4. A mistake of fact must be honest and reasonable. Mistake of law. 1. A mistake of law occurs when someone has an incorrect understanding of the law. 2. A mistake of law is really a defense because people are expected to know the law. And 3. A mistake of law may be a defense if the law was not published, or if the defendant relied on an official source that gave incorrect legal advice. In contract law, a mistake of fact can be used to avoid liability, cancel, or reform a contract. A mistake of fact is when someone has an incorrect belief about a fact, while a mistake of law is when someone has an incorrect understanding of the law. Examples of mistake of fact. 1. A salesperson accidentally misprices an item. 2. A blind person jaywalks because they believe they have the right to do so. 3. A person apprehends someone they believe to be a burglar, but it turns out to be the homeowner. 4. A buyer purchases a book with a forged signature, unaware that it is forged. 5. A person takes someone else's property believing it to be their own. And 6. A person takes another person's dog home, believing it to be their own. Examples of mistake of law. 1. A driver is unaware that driving without a license is illegal. 2. A defendant relies on a law that was later overturned or deemed unconstitutional. And 3. A defendant relies on a judicial decision that was later overruled. In general, mistake of law is not a strong defense because courts expect people to be aware of the law. However, mistake of fact can be a defense if it negates the intent required to commit a crime.